Any mention?
Please, Your Lordships. So I pray for an adjournment of item 15. So we are filing the affidavit on bringing on record the screening committee composition today. I am praying if it will be taken up on Wednesday, Lord.
Senior, I have already prepared this matter.
Ajong?
My senior has already prepared this matter to the hearing today.
We have not yet filed the affidavit, but we are filing it today.
What screening committee?
Lordship would recollect after lengthy hearing, we wanted to file an affidavit to bring on record the composition of the screening committee. And thereafter the matter was to be heard on maintainability. So I am praying if it may be taken up on Wednesday, Lordship. We will file the affidavit today.
Mr. Stan has objection.
I'm for HL Sangreso.
We have informed Mr.
Oh, sorry, Mr. Sangre's objection.
Yes. Since he prepared it from yesterday.
I am only praying for Wednesday, Lordship. So we have not yet filed the affidavit.
Prepared whole of last night.
We had served the advance copy to senior counsel.
Yes.
Just received the affidavit today, this morning.
Wednesday, Lordship. I am not asking for further time.
Where's Mr. Sen?
So we had informed him, Lordship, about the situation. I think his juniors.
The seeking time. Yes. Where's Mr. Sen? Mr. Chandra,
we have a serious objection. Lordship has really, they have really enjoyed the opportunity. And Lordship has particularly fixed for maintainability. On the ground of maintainability, we are prepared.
No, but the thing is that he's not prepared.
So I'll file my affidavit today itself, Lordship. I have served copies to all the parties.
We have seen, it has nothing to do with the maintainability.
That's correct. So kindly have it on Wednesday, Lordship, for hearing on maintainability.
Yes, Mr. You have no objection.
Receive this.
Okay,
Just
on Wednesday.
Wednesday, Lordship. I am obliged. I am obliged.
Mr. S. Deb please that the matter be taken on Wednesday as the affidavit,
Will be filed today,
with regard to the composition committee is being filed for the day itself.
Lordship.
Stop with HL Sangreso. Then council respondent number
6.
Number 6 has very strong objections and submits that affidavit has no relation to the question of maintainability, which is been fixed for hearing today. Because it may the objections noted. However, for the ends of justice, that the matter be posted on Wednesday as a fixed item. Wednesday is the 25th.
Lordship.
Yes.
I'm grateful, Lordship. Obliged. Lordship, I also have a similar prayer for item 20, Lordship. This was the Lordship, extension of the tender.
Why you want time?
Required to place certain citations, Lordship. We are unable to on the issue of whether the agreement could have.
Go and file a suit.
I'm only praying for 1 week time to produce the
File a
citations.
suit and withdraw.
We have got certain judgments.
Why should we just continue with this?
Lordship, allow us one opportunity to just place the judgment.
You know what they call beating a dead horse?
Lordship, yes, it's not a case of, my lord, beating a dead horse here. There is some scope of interference, Lordship. Kindly allow us to place certain
Some scope of that horse coming into life.
Lordship, perhaps, yes.
It's still June only, my lord. We can adjourn till June, I think.
I'm asking for 1 week time to just produce the authorities, Lordship.
Tactical adjournment or?
Lordship, no, Lord. In fact, the adjournment goes against us as learned seniors.
Tactical means you're prepared. Yes.
1 week to just
2 weeks, yes. Or give you enough time.
Very
But 2 weeks, I'll have some difference. 3 weeks.
3 weeks, okay. Yes.
obliged.
Yes.
With please, Your Lordship. My Lord, I beg to make a mention of item number 22 of the hearing list. Lordship, the conducting counsel is out of station, my Lord.
Who is you bidding for?
For the sole respondent, Your Lord.
No objection?
No objection.
Yes. After?
2 weeks, my Lord. Obliged, Your Lordship.
Much obliged.
Lordship, I beg to mention item number 17 and 18, both are connected matters. Let this matter come after 2 weeks.
Who's the other side? What's the matter about?
Lordship, is a promotion matter.
Some rifles?
No. It's BSF.
Who's Mr. Pandey leading you?
Yes, Mr. Pandey. He's out of station. Lordship.
Okay.
Obliged, Lordship.
What is your name?
G. Chetri.
Record his name. Yes. G3.
Please, Your Lordship. Lordship, I beg to mention item number 19.
Where's Mr. P.T. Sam? You have objection?
Lordship, in 19 actually we file a miscase. We maybe come up on next week.
Let it come up. We'll take it up now only. What miscase?
Or 23.
19.
Oh, no, okay, 19, no objection, madam.
What's the matter about?
This is regarding pension.
Why pension take adjournment?
They are taking time.
Yes, why? What is the status of the case?
They have filed the affidavit.
What is in affidavit?
Now, only thing is that they have the GHDC have already given a sanction to the petitioner. So on the basis of that, then that sanction is given, but money has not been paid. Is it their own sanction order, my lord? We that's page 9, annexure 1. Release.
Well, this is a case where golden handshake was given, so the matter was fixed for hearing, Lordship.
She's already taken money.
Lordship, yes.
Then what do you want now?
We have not
What's the prayer
received.
here?
She took BRS. I mean,
Pending
rather,
salaries of
she
4 years.
resigned. She resigned, and a golden handshake one-time package was given to her.
So what right now? Why you want salaries? After
Lordship,
where have you disclosed that you've taken golden handshake? No, my lord. Then
No, golden. This is not golden. Gratuity. 1 month. Some have been paid, but
where have you made the pleadings in your resolution?
Lordship, my pleading is there, Lordship.
Where is that?
This is
What gratuity?
He's asking for areas of salary, my lord.
the para 3, my lord. In my
Karasi
pleading.
DNS allowance. Arrears for salary.
Lordship.
There is
If you know what golden handshake means.
What is
not
pertinent is
golden handshake note that there is a due to be paid in the para 3 have mentioned, your lordship, which I that the humble petition is entitled
No, when
payment
you
of
paid earlier.
DNS allowance arrears
Lordship, we have
salary
paid
for
everything,
period of
according
This one 5,42,000 you've paid.
Lordship, according to our thing, we have paid the entire thing. Lordship, we have paid a total amount
we are
of
saying that we have not received, lordship. We have not paid.
542. We have not paid, my lord. We have paid.
Let them show that any sort of document that they have cleared to us, they have
We have
paid to
paid
the petitioner.
3,32,000 rupees.
No. This letter
See-
dated or first office order dated 2/6/2025 shows that they have you've
Kindly,
calculated the amount payable to the petitioner
Lordship, yes.
of 5,42,000.
yes, this money has
How do
not
you say
been
golden-
paid.
It doesn't matter. Keep it back. Yes. How do you say it's not been paid?
If Lordship would
How do you say it's been paid rather?
it's this 5,42,000, my lord. This is probably a miscalculation because what has been done is that 3,32,000 has been paid, Lordship.
This is the document issued by the Secretary to the Executive Committee, Garbage
Received it
Administration
in-
Council,
received
during
it
the pendency of this petition.
Received it in 2022.
Yes.
He received it in 2022, my lord.
So what about the
Then if they have
calculation 25?
Lordship, that is perhaps we have to. That was wrongly, my lord. If kindly
What do you
see
mean
the
wrongly? It's
affidavit,
your
my lord.
document.
Lordship, yes. There is some, Lordship. Because
They have
that's
issue
why the
on,
matter was fixed for hearing. There are some issues because
no,
in
this is the sanction they are not
second,
disputing.
one second.
Lordship, I'm sorry.
because what happened, my lord, is that in the writ petition he had made an assertion that he had taken VRS.
See out here in this annexure 3 of yours, 9 months salary, 2,22,000 for the one-time package, 1 lakh,
Lordship, yes.
3,22,000 was paid to her. Correct.
Yes.
Now she received that
She
amount.
received it on 19/9.
She signed it, yes.
Lordship, yes.
On 19/9, 16/9 and 28/9/2022.
Now, these are not disclosed in the petition at all.
No, fine,
that-
whatever. But then, where did this amount come from, which you have
Yes.
the letter given to her? This order.
Lordship, we have sought instruction on this part, Lordship.
Then why you think adjournment today?
Lordship, Mr. Day is not here today, so I'm praying for 1 week to just because that's why the matter was fixed for hearing, Lordship. Because there's some.
You take down technical matter. This is item number
19.
19. In the instant, this matter concerning the claim for arrears in salary, as also generous allowance.
Prayer is only for
Is
pending
fixed for-
salary, my lord.
Yes, is fixed for hearing today. Stop. Mr. S. Deb, Senate Counsel for the respondents number.
All the respondents, Lordship.
All the respondents, bracket District Council, has submitted that whatever arrears due have since been released to the writ petitioner,
Lordship, yes.
which is amount of rupees 3,22,340.
Lordship.
So, however, with regard to an office order dated 2/6/2025, which shows that the petitioner is due to get 5,42,268,
Lordship.
which consists of revised arrears, pay arrears, and day arrears. Mr. S. Deb submits that this may be a miscalculation, even though the same even though the order has been passed on the hand of the Secretary GHADC, Secretary GHADC. So he prays that without to obtain instruction.
Lordship. Matter, we'll take a, we have actually sought for, but perhaps
No,
the instruction
actually
has
that
not come
payment
to
is
this now.
separate, Lordship. This is another one which this is my due.
Disclose anything in his petition, Lordship.
Just have to tweak for specific instructions. Yes.
Lordship, 23 will be called out, Lordship. 23, they have filed a miscase.
We'll take it up. We called out.
Lordship.
Yes.
First place.
Yes.
May I please, Your Lordship? I beg to mention item number 24, my lord. My lord, I'm seeking for 2 weeks' time. my lord.
Lordship.
No objection? No. Okay, yes.
Hello, my lord.
Yes.
Wait for Lordship.
Supplementary list item number 1.
My lord, the challenge is to order at Annexer 8, page 44. By this order, my lord, under exercise of section 69 of Assam Rifles Act, 33%, my lord, deduction from the monthly pay towards maintenance has been ordered, my lord. My lord, there are attending circumstances, and also the law is clear that section 69 cannot be without adjudication automatically, my lord, imported. So there was no adjudication, and irrespective of that, as of now, I am okay, my lord, that towards the wife and the children, maintenance should go till the matter is finally heard. But then at least, my lord, the arrears from 2025 may not be recovered, my lord. That is my limited prayer as of now.
Yes, Dr. Mosika?
So we'll have to file affidavit.
No, what is the exact situation? What, section 69? Was he heard?
It appears, my lord, there is no notice given to him.
Yes. Who has impugn order?
Page 44.
My lord, page 44, my lord. In fact, the eldest daughter is living with the petitioner, so therefore, my lord, he has responsibility towards her also.
So this order since December, my lord. I'll just have a station whether already deducted or not deducted. My lord.
We'll have to after 1 week. Yes.
My lord. My lord.
Well, Mr. B. Batak, becomes a petitioner, issue notice, Dr. Mosika, with so-and-so is present on behalf of the respondents. No further notice to the Sir, respondent notice to go to respondent number 5.
Yes.
Yes, within 2 days. Yes, within 2 days. Top next paragraph. The writ petition is directed against the order whereby writ petitioner has been directed. Order whereby that against the order passed under section 69. 1. 69 small 1 of the Assam Rifle Act 2006, whereby deduction, where has been ordered for deduction of 33% of 33% of fee and allowances of the writ petitioner for payment of maintenance to wife and 2 minor children. So, next paragraph, Dr. Ambedkar obtained instructions just after 1 week is.
Item number 2. Item number 2.
Item 2, my lord, it's a transfer order. We are not prima facie against the transfer, my lord, but then we are seeking a sympathetic consideration that the 2 minor children, my lord, the place where the petitioner has been posted now, there is no accommodation, my lord. So during this 2 months holiday, my lord, May and June, the petitioner is praying with a limited, my lord, folded hands that she may be accommodated at the current place of posting till at least 30th of June, my lord, 2026.
What is the reason?
My lord, there are 2 minor children, my lord.
Para 10.
And during the
At page 7. The children will come to stay with her for 2 months, school holidays.
Well,
that's very weak ground, my lord. Para 10.
No, but then it's a very human ground, my lord. And
during the month of April, children live with her at duty place every year. He's posted where now?
At Ceylon, Manipur.
She's
There's
posted
no accommodation there, my lord. In fact, had there been accommodation there, my lord, at Ceylon. Had there been accommodation, we had to move, my lord.
But transfer.
Other children are in Kerala, my lord. She's saying that during summer holidays they'll come here, so she wants to. That's a very paramilitary force, my lord.
Is that the ground for staying transfer? That
No, my lord, I'm not praying for a stay. I'm praying that, my lord, the 2 months might be
for interfering with transfer order. Movement order has been issued.
No, my lord. No, my lord, because in the current hospital there is actually a deficit of nurses.
No, has a movement order been issued or not?
But the transfer order is since October, my lord. October 25. It's 23, my lord.
No movement order issued, my lord.
Then relax. Maybe there will be no movement order until June.
Movement date was 1st December. Page 23, lords, you kindly see, my lord.
Where is it in?
Page 23 at serial number 1.2 in the table. Mantri Pokhari to Ceylon.
But she didn't move then?
1st December 25.
So thereafter the case.
I'll just have instruction on it. Comes after next week.
We'll just have it next week, yes. Same order. Heard Mr. B. Pathak when Contempt petition issue notice. Dr. Mbozika with so is present. No further notice from the respondents. Just after 1 week for instructions, yes.
Obliged, my lord.
Daily list item number 1.
Well, in this matter, my lord, we had filed an application seeking impleadment. They were required to file an objection this short time.
I'll be filing in the course of the day, Your Lordship, my objections.
The miss case?
Yes, Your Lordship.
Let them serve a copy on me.
Mr. Pasanti, learned counsel for the petitioner, submits that the objection in miss case WPC number 17 of 2026 will be filed in the course of the day. So this is a matter after 1 week together with the miss cases.
Right.
Huh? That was another miss case. What's another miss case? Filed by?
Yes, my lord. I had filed one miss case for bringing additional documents into, but they're not on board. That's why I did not say anything. They're not in the cost list.
It's not the cost list. 96. I'm done. MSOIA Bank has also submitted that MS case on behalf of respondent number.
Respondent number 1, my lord.
Respondent number 1, being Miss MC bracket WPC number 9626 has been filed. List the same together on after 1 week.
Yes, ma'am. Most good. Item number 2.
Your Lordship, I filed a miscase here for completed newly, but there is some mistake in my prayer. So I'm wondering I may be allowed to file a fresh miscase application because
contempt application or miscase application?
Miscase application.
What miscase?
To implement a new this one. There's an order, Lordship, whereby on the last occasion the order dated 26/02/2026 I was allowed to file a miscase application to implement the necessary party. Actually,
then as the pleadings, you will close it. You will give liberty to file fresh.
Lordship,
there seems to be a defect in the contempt application as well as the miscase file. The contempt was closed. However, petitioners it's allowed liberty to institute fresh proceedings if so advised.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 3.
Oh yes.
I'm praying for
instructions.
Lordship, we have just received the corrected copy, Lordship. I'm praying for some time to obtain instructions.
Who received? You just served a copy?
Yes, Lordship. We have served
today.
Today morning.
Not today, on the last occasion, because that petition has already been served. Only the corrected one is also the same thing we have given. They are just
1
89.
week's time allowed for instruction. Yes.
Lordship.
Obliged.
May it please, Lordship. Lordship, this matter was placed before the mediation, my lord, but it was not fruitful, my lord.
Yes.
My lord, I'm praying for 2 weeks to file the affidavit, my lord.
Mr. Jandanja submits that as the mediation proceedings were unsuccessful, he may be allowed to file affidavit. Yes. It is allowed. List after 2 weeks. Yes.
Deeply.
5.
May it please, Your Lordship. Lordship, I pray for some more time to file the affidavit.
What is one number?
124. 124.
124.
Similar prayer for 1528.
Any urgency?
Urgency, my lord, but
How many times you prayed for affidavit?
3 weeks.
How many times?
This is the second occasion, my lord.
Okay, as prayed for the 2 weeks allowed to respond for affidavit. Yes.
Obliged, Lord.
6.
Wait, please, Lordship. Lordship, affidavits are awaited from the respondents.
1, 3, 6, and 7.
Lordship, I'm craving your kind indulgence, my lord. Can we grant me some time to file the objections and
You're appearing for the state.
Lordship.
You're appearing for?
My lords, I'm appearing for MECF.
4 and 5.
My
You
lords,
file affidavit.
my lords, I want to address on the issue of maintainability of the present document.
You file the objection. What you're ready with the issue now? Yeah. What is the question maintainability?
My lords may have the Telegraph Act, my lords. There's an alternative remedy, my lords, which is available.
So this arises out of the order passed by this court.
Without
This is the
prejudice to
second
that
round of
vermin, my
litigation.
lords. My lords may have 16(3) of the Telegraph Act, my lords.
Section
16(3), my lords. May I read, my lords?
1 second. Yes.
My lord, 63 reads as under: if any dispute arises concerning the sufficiency of the compensation to be paid under section 10 clause D, my lords, it shall, on application for that purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated, be determined by him, my lords. My lords may have section 10, my lords. This is the power of the telegraph authority, my lords, to place and maintain telegraph lines, which in the present case has been done by...
This is telegraph lines.
Please, my lords. It's transmission lines, my lords.
Electricity lines.
So will the Indian Telegraph Act apply?
Please, my lords.
What does the early order say? It's not on this bench. Yes.
My lords may have the impugn order. My lords may have paragraph 31 of the impugn order, my lords.
Which
It's at
the impugn
page
order?
number internal 41, my lords, of the impugn order judgment.
Yes.
My lords, may I read?
Yes.
A look at the above mentioned provision would make one to understand that the Telegraph Authority is at liberty to place and maintain telegraph lines and posts over any property. However, Proviso C of said Section 10 makes it incumbent upon the Telegraph Authority to seek the permission of the local authority who controls and manage. My lords may skip that portion. My lords may come to this line which says that it may also be mentioned that the power of the Telegraph Authority conferred by Section 10 of the Telegraph Act stands vested and enjoyed by the State Electricity Corporation, MEPDCL, my lords, as these wordings are found at para 22 of the Power Grid Corporation versus Century Textiles, my lords. In light of which, my lords, I'm placing reliance on the Telegraph Act's Section 16.3, my lords, which gives them an alternative remedy per se, my lords, without prejudice to the above.
What was the outcome of this case? What happened?
Lordship may see paragraph
What was held here?
40, my lord, page 45. Be that as it may, under the peculiar facts and circumstances of the case of the parties herein, in an equitable approach of the case of the parties herein, this court finds it proper to allow the said 33 and 11 kV HT lines to remain as it is, in the same place, since shifting of the same would entail enormous costs, which would not be payable to the petitioner under the
So in
circumstances.
your present petition, what are you asking for?
Lordship, now thereafter, after this direction, the Deputy Commissioner was directed to...
No, what are you asking for here? Where's the prayer?
My lords may have their prayer at page number 24, my lords. My lords may have just look at their prayers. They're asking for reassessment, my lords. This is a disputed fact, my lords.
1 second.
Page 24, my lords.
Yes. Was he asking compensation now?
Lordship, it does not flow from
Then?
section 10, my lord. If Lordship would
It doesn't
see...
mean that the directions with that another suitable place be afforded to you. So it's not that they have not complied with the order.
Please, my
So that
lords.
is also not
You're
done.
asking for compensation again.
Lordship,
Reassessment, my lords.
because what has happened after the direction has been
To put
passed...
an affidavit.
Please,
Yes,
my
let
lords.
them apply.
Let them file it.
Yes, Sunto, Mr. Jen Renja for respondents number
1, 2, 3, 5 and 6.
1, 2, 5 and 6 praise for further 2 weeks time to file affidavit on behalf of the respondents. And your name, sorry?
Miss Ice Emily, my lords.
MSM Ice Emily for response 4
4
and
and
5.
5.
However, the raised questions as to the maintainability of the instrument application. Learned Counsel has drawn attention of the court to the section 16.3 of the Telegraph Act, which stipulates that any matter regarding compensation and alternate remedies fail will stop. She prays for permitted to bring objections on record of the affidavit. Ms. S. Deb for the
I'll file a rejoinder as and when they file the affidavit.
at least after 2 weeks.
Grateful, my lords.
Published.
7.
The affidavit is yet to be filed by them. my lord, from the
Please, Your Lordship. Your Lordship, I'm praying for some time on
What
behalf
matter
of respondents. Want to
matter concerns, my lord, the election to the VEC, my lord. They have not held any election even after the expiry of the term of the VEC, my lord.
Rajabala,
No, my lord.
Mora
It is
City, VEC,
Mora City village.
Your Lordship.
one of those areas only.
Yes, my lord, the plain bells of Garwals.
When is this matter filed?
Last year, my
December,
lord.
Your Lordship.
I'll wait for the 2 weeks time allowed. Yes.
Obliged, Your Lordship.
8.
Your Lordship, I'm making a similar prayer in this matter.
Yes.
Your Lordship.
No objection. Yes. For the 2 weeks time allowed. Yes, I'll pray.
Obliged, Your Lordship.
9.
May it please your lordship. Lordship, we have filed the affidavit in opposition on behalf of respondent number 2, who's a competent authority. On behalf of the other respondents, lordship, my instructions do not answer the petition at all, so we don't propose to
File an affidavit.
file any affidavits for the rest.
Your Lordship, we have received the respondent affidavit. We won't be filing any
Rejoinder.
rejoinder.
Yes,
Kindly fix
yes,
this
the
matter
Learned
for
Counsel
hearing.
for respondents submitted an affidavit on behalf of the two since been filed, which will answer the other, which will suffice on behalf of all the respondents. Stop. Your name?
Dibuan.
MS Dibuan, paragraph on behalf of petitioner submit no rejoinder will be necessary. Well, this is a matter for hearing and so on. So yes.
Brief, Your Lordship.
Then,
2 weeks time can be allowed, Your Lordship.
Lordship, with regard to respondent number 11 and 13, they have resigned, Lordship.
They have?
So, resigned.
What's
So
the matter about?
This is the petitioner here in aggrieved the radiation list, Lordship.
So we'll strike them off.
Yes, 11 and 13, Lordship.
They have resigned?
They have resigned, Lordship.
Correct.
Lordship, I have no.
1 second. 11 and 13.
11 and 13,
That
Lordship.
is,
Which one?
you're all serving as assistant engineers.
Assistant engineer, yes, Lordship.
Which are the people who have resigned?
13.
What's the matter about?
This is concerning promotion, Your Lordship.
They've resigned. You sure?
Yes, Lordship.
Let's strike them off. Yes.
And petitioner number 2, he does not want to continue as petitioner, Lordship. So his name may be struck off, Lordship. Petitioner number 2.
Then you have to make application. Yes. If court's own motion can take cognizance and strike off, but then you just Mr.
J.M. Sama.
J.M. Sama, yes. The council petitioner submits that at the outset submits that the petition number 2 does not wish to pursue the matter any longer. The praise and be allowed to bring an appropriate application indicating this fact. Stop. Next. He has also submitted that the respondents number 11 and 13 have also since resigned from the post. Stop. The next.
Lordship, we need 2 weeks time.
Mr. N.D. Shulai, learned
1 to
PhD
6,
with so and so for
1 to 6.
1 to 6, and Mr. S. Chanda for
Number 7, 8, 9, 10, and 12.
so it's one number 7, 8, 9, 10, and 12. Pray for and allowed for the 2 weeks time to file an affidavit stamp. As is submitted that 11 and 13 since they resigned, these 2 respondents shall accordingly be struck off from the array of parties. To make necessary corrections. You put an application with the petitioner. We don't want the petitioner coming later on and say that I never withdrew from the case. Yes.
11.
Yes.
Please, Your Lordship, in this matter, pray for some more time, Your Lordship. Respondent number 2 and 3 were supposed to file affidavit on behalf of Nehu, Lordship. Yes, Lordship.
You're for Nehu?
Yes, Lordship.
How much time?
2 weeks time, Your Lordship.
Your name?
Slamat.
S. Lamat.
Yes.
How do you spell it?
SLAMAT.
L-A-M-A-T?
Yes, Lordship.
Last time we told me. Just we take down the name correctly, yes. Praise for on behalf of respondent number
2 and 3, Lordship.
2 and 3, praise for and allowed 2 weeks for the time to file affidavit, yes.
12.
May I please, Your Lordship? Your Lordship, this is a transfer petition which I have invoked section 24, clause 1, subclause B of the CPC. Your Lordship, there are 2 grounds which I had invoked section 24 of the CPC. One ground is I had mentioned in my writ petition, in my pleadings, that is in paragraph 9. Your Lordship, that is page 7, Your Lordship.
Yes. Now, why is seeking transfer? On what grounds?
Your Lordship, as I have mentioned in my pleadings in paragraph 9, there are two suits
Yes.
already filed in the Assistant to Deputy Commissioner or Judicial,
Yes.
two suits, that is TS 8 and TS 16, relating to the same subject matter, Your Lordship. That is the same issues and the same subject matter. And also, if these suits were transferred before the Assistant Deputy Commissioner, there will be no conflicts of judgment or decision by the court. Your Lordship, here, and that also, Your Lordship, I have annexed it, those TS 8 and TS 16 in the annexure, that is page 43 and 290. So the main ground for my invoking section 24, Your Lordship, is that the same issues is being related to the same issues and the same subject matters of all the three title suit. Your Lordship,
So one suit pending is the council, other one pending for the regular.
and two is pending in the regular
For
court.
regular civil court.
Yes,
And
and one in district council court. So the same subject matter, Your Lordship, and the same ground. And relating to the same property, which has,
If the same property, they can be tried together.
yes, that is the thing I want, Your Lordship. That is I had invoked.
May I please, Your Lordship? Lordship, we are not agree with the transfer. We do not have objections on that, Lordship. But the prayer made in there, Lordship, it's a I go to the prayer, Lordship. The prayer, we have an objection to that. She's already with here the petitioner is saying with the liberty to implead tenant as a pro forma defendant. Now this is not in the cause title,
Your
Lordship will say, and Lordship, if I may be allowed, Lordship, this is a matter which has already been heard by the learned trial court below.
No, that is a
Yes,
different.
yes, that is a different
consideration.
Yes, Your Lordship.
The transfer only.
That one is.
Yes, this has been interpreted by the respondent wrongly. Yes, yes.
I am not
That your
interpreting it. Yes, Lordship.
Relief will you get the trial court?
Because which has already been
And if
heard.
rejected, then you have your revision or appellate provision is to take down. Why you file 227?
Your Lordship, it's I thought this is a civilian power of the High Court
No, because
for
it's
the
anyway,
administrative
take down.
subordinate court.
There's an application under section 24, bracket 5 CPC for transfer of title suit number 47 of 2024 from the court of Shri E.E. Gatpur, Sub-Audit District Council Court, Shillong, to the court of the Assistant Deputy Assistant Deputy Commissioner, East Kasia, Shillong. A petition person has submitted that the transfer is sought in view of the fact that the matters which are substantially in issue in the case in the suit sought to be transferred are already before the court of the Assistant to Deputy Commissioner, T.K.K. Missile, in title suit number 8 of 2025
And 16 of 2025.
or 2024, 25.
24, Your Lordship.
She submits that as for ease of adjudication. Transfer has been sought. Stop. Now, next, sir, you have no objection. MS SK number appearing for respondent number.
Respondent number 2.
You are the plaintiff there
No, I'm the plaintiff.
in all the suits.
No. She is a plaintiff in TS 16,
16.
and the respondent number.
No, in this council, who's the plaintiff?
I'm the plaintiff, Your
So
Lordship.
then, yes, all right. Then, MS SK number appearing for the respondent number 2.
2.
Who is the plaintiff?
Who's the defendant there in also?
Just give the number defendant in
In
all the suits.
In title suit number here in District Council is 47.
In TS number.
TS number 47 of 2024.
Before the presiding of the district council, as also defendant in.
One of the defendant also, and
Defendants in
16.
TS number 16.
in 16 I am not the defendant. Here it is it's my mother who has filed The
I
petitioner
have mentioned in the paragraph, Your Lordship.
it is the mother who has filed in 16.
No, we just said it was the defendant in. Your
So we
defendant,
just-
yes, 47.
Yes.
Yes, has no objection to said transfer. Anyone else, anything to say? Mr. Wanswet, you appeal for whom? Who are you?
I'm the.
She is the sister-in-law.
You have no objection also.
Just this, the prayer part for the implement of the penalty.
No, that is that's
Yes. Mm.
Yes, Mr. Wanswet, appearance for number 3, who's also a party in the proceedings, also has no objection. According to the prayer of the petition and person is allowed, and TS number 47 of 2024 does that stand transferred to the court of Shri EKK Missile, Assistant to Deputy Commissioner, along to be tried together with TS number 8 of 2025
Yes.
and TS number 16
16.
of 2024 pending before that court stop. With regard to the other prayer made by the petitioner, the same not considered by this court. Stop.
Your Lordship, I'm appearing for respondent number 1.
Or for this counsel, as appropriate relief be available for the trial courts itself. You have Mr.
M. A. Ladman.
Yes, Mr. Responsible. Matter stands at ordered above, matter stands closed and disposed of.
Much obliged, Your Lordship.
13.
May it please your lordship. But you need 2 days time, your lordship. For filing the affidavit, your lordship. We serve the copy to the.
We've been served with the copy, man.
We're going to inflict costs on you.
My lord.
Yes, 2 days. Mr. Andy Schleip, please one load for the next time to file affidavits.
Obliged.
14.
Item number 14, my lord, this is a promotion matter, my lord.
We please, Your Lordship. I'm praying if the matter could come at the end of the board, Lordship.
End of the board, you ready with the matter?
Lordship.
It's for hearing.
No,
This is a covered case, my lord.
End of the board, after some time.
Highly obliged.
My lord.
Was government, yeah.
Deeply.
Hearing. Supplementary list 3.
I have similar prayer in this matter as well, Lordship.
A par. What is the
16.
Against the order dated 1/5/24, cipher categories, my lord. Not compliance that order, my lord. Matters pertain to the ACP and MACP scheme, my lord.
Lordship, I have similar prayer in this matter as well, Lordship.
End of the board.
End of the board, Lord.
End of the board, after some time.
Highly obliged.
My lord. Deeply lordship.
21.
We please, Your Lordship.
End of the board.
End of the board, Lordship.
Ready with the matter?
Lordship, they were supposed to file the survey report, Lordship, in this matter.
Is it ready?
Lordship, we're ready with the report, Lordship.
With the report?
Lordship.
After some time, yes.
My lord, we are from the cantonment board. Since we have been not added as parties.
You know, others parties?
No,
In the minute, you've not included them as party.
At that point, relevant point of time, they were not required, Lordship. Only I think now, in view of the survey, Lordship, I think they have come into the picture, Lordship. So, if Lordship directs, then Lordship, we can implement them as a necessary party, Lordship.
That if we are added as the parties, then we can file the affidavit next week and the report of the inspection as well.
Why you didn't make them a party? If you're contesting, you know, the fact that your property might be within the you're Mr.
Kedip.
Lordship, here what has happened, Lordship, we had challenged the order of the different state officer, Lordship, only to the limited effect, Lordship.
Has though not a party to the proceedings, has submitted that he represents the cantonment board, who is vitally interested in the matter. So, he prays that he submits that for further adjudication of the matter, perhaps the cantonment board should be added as a party respondent. So, Ms. Chanda, you bring an approved application.
Lordship.
Ms. Chanda and the county police please to file an application
for implement
the cantonment board by the next date. This after 1 week.
Lordship. Hello.
Please.
25.
Head of the board.
Lordship.
What's the matter about Mr. Chaudhary?
Yes.
What's the matter about?
So matter is actually for VRS, Your Lordship.
Oh yes.
I am seeking VRS. And this is almost a covered case of this Honorable Court, Your Lordship.
Sure. Yes.
Your Lordship, I have been posted as the Assam Rifle Composite Hospital, Sukobi, presently, Your Lordship, at Dimapur, Nagaland. And meanwhile, I have completed my service of years, 22 years service, and I have been appointed, Your Lordship, as a combatant capacity of Commandant CMO, having enrolled on 5th May of 2003. So from 2003 till the date of application, Your Lordship, my representation, I have completed my 22 years service, Your Lordship.
One second. Yes, what are you saying?
I'm saying, my Lordship, my appointment is on 5th of May 2003. Your Lordship.
2003, right?
Yes.
Yes.
And presently, when I filed the petition, I'm posted at Composite Hospital, Sukobi, Dimapur, Nagaland, Your Lordship. And meanwhile, I have completed my service of 22 years as on May 2025, Your Lordship. So my application is basically filed, Your Lordship, caring. I'm seeking the relief under section for violation of this section. Wait. This is under section CCS of 43, Your Lordship.
Voluntary retirement?
Yes, Your Lordship. So 43 is speaking about, Your Lordship, retirement on completion of 20 years qualifying service, Your Lordship. So here, Your Lordship, I have completed, there is no dispute at all, Your Lordship, from the respondent side also, that for regarding my service, that completion 20 years. So this is completed, Your Lordship. And in this regard, Your Lordship, after submission of my application, the respondent has denied my application, stating
Reason?
the reason they have stated shortage of radiologists, Your Lordship. Please,
yes.
Please kindly, Your Lordship, can go to the Annexure 5. It is there, page number 29, Your Lordship.
29.
Yes, Your Lordship. So here, Your Lordship, they are saying voluntary retirement. Please refer para 3 of your letter dated so and so, dated 12th February 2025, which was in response to my letter number so and so, copy received after almost 2 months of my application. So I have stated the reasons for voluntary retirement from Assam Rifle Service on extreme domestic commitments, Your Lordship. In view of the ongoing extreme domestic issues in my family, I regret to inform you that I refused. So this is my refusal, Your Lordship, and kindly see, Your Lordship, page 28, where they have denied my application. Page 28, my Lordship.
Yes.
So, in the third paragraph, Your Lordship, keeping in view of the organizational interest of Assam Rifle and desire of competent authority to provide better healthcare delivery, serving personnel of air and their dependents, your application for voluntary retirement is not recommended by Director Medical of Assam Rifle. Accordingly, you are requested to withdraw your application. Rather, without considering, they have actually requested me. So, in page number 29, I have further requested that this is an extreme requirement for me, because the ground I have stated in my petition, Your Lordship, kindly see in para 3 of my petition, where I have stated what is the reason.
What is the technical reason? Any technical reason, or just on shortage of manpower?
Shortage of manpower.
Shortage of
manpower. Let him go.
And secondly, there is no right to resignation. There is no right to resign.
I've seen before, yes. Right. No right, but then 22 years he served.
Yes.
You can't reconsider.
Because that's the only difficulty, my lord. It's very difficult for us now to get the medical.
What's the position now?
There are only 2 radiologists in the
Now
entire
also,
force.
you sure?
Yes, my lord.
Your Lordship, what is my exigency I have stated.
What is your right?
No, right means this is not I'm saying right, Your Lordship, my humble submission. I'm saying this isn't because my son is little bit mentally destabilized. For that reason, and he is studying at Nagaon Medical College.
Have you made, he's studying, have you made that, have you put that before the authorities that you're seeking retirement because of your, you know, your personal...
Yeah, Your Lordship, in my application. In my application, it is there.
Your son suffering from mental deficiency.
No, regarding not my son, I said actually this is my personal commitment for the domestic reasons because I'm only alone, Your Lordship. That is.
Let him place all his grievance, my lord. A fresh representation, my lord.
Not that actually my friend is
considering all this.
My friend is trying to actually.
One thing that your son is suffering from.
From mental little bit destabilized. He cannot actually. He was not stable. But later on, after 1 year loss, he got admitted in Nagaon Medical College further. After loss of 1 year.
He's doing MBBS, my lord.
MBBS.
No, it's not that he's suffering from some mental ailment.
No, initially it was that. He dropped 1 year, Your Lordship.
No, that's not mental ailment. That might be depression.
After treatment, he recovered, Your Lordship.
You were depressed?
Yeah, depression. He got depression actually.
How many children do you have?
How many children? Two children. 2 sons only.
So that's your eldest son who got admission BBS now?
No, he's the second one.
What's your first son doing?
First son he's doing. Oh, he's the first one. Sorry.
What's your second son doing?
Second son is studying. He's in studying class 12, I think.
So where is he staying with you?
I'm not sure, but maybe with him, Your Lordship.
Your wife's with you only?
Yeah.
And son studying in Sukovi?
School, yeah, Sukovi.
So only your elder son?
Only your eldest son.
Any other pressing domestic problems that you have?
No, this is the reason because he needs every time my care, Your Lordship. And for that...
So he's studying MBBS where?
Nagaon Medical College, Your Lordship.
He'll go in Nagaon and stay with, I don't think he'll be allowed to stay in hostel.
So he wants to accompany actually, Your Lordship. He's
studying in hostel in Nagaon Medical College only. Basically, they want to resign, want to start private practice. That's the trend now.
Naturally tired of army life. Want to relax also. You serve how many years with Assam Rifles?
22 years, Your Lordship.
I don't see any compelling circumstances anyway. Where's that with CCS 43?
43 is there, Your Lordship. This is page 6 I mentioned, Your Lordship. Page 6 of the petition. And 43 is that retirement on completion of 20 years, Your Lordship, qualifying service.
Yes, where's that?
Premature retirement and voluntary retirement. Chapter 6.
Now, where's the rule? Where's that? Where's rule 43?
CCS rules for that.
Oh, this is the rule.
CCS pencil rules.
This is a Xerox copy I have, Your Lordship. नहीं होगा देखो वो देखो
Leave rules.
42 here. Pages are missing out. Pension rules 21. Pension rules 2021.
2021, yes.
2021?
2021, my
I think this is the old one.
I have RGB.
1972.
This is the new one, Your Lordship.
Which one?
Amended one. Yes.
Yes, where's 21? This is an ancient one. I put it What is this? Pension rules? One second, one second. No. Four, 54, 50. There you go. You got the copy.
Not so. 243. It says, well, around completion of 20 years of service, an employee can, by giving 3 months notice.
Where's that? It's not a right. That's why the government shall complete some right.
In my affidavit, lots of kindness.
Yes.
Page 3, my lord. Subpara D. Is a combatant person and member of Assam Rifle Force that is subject to the Assam Rifles Act and his service regulated by the Assam Rifles Act 2006 and rules 2010. Section 3 of that says that.
That's what I remember is Assam Rifle Act.
Then section 8, my lord. Then rule 27. And a Supreme Court decision of Subrata Das, my lord.
So the thing is that it's you only and you come under 27B, 27.3B.
B,
27.3B.
Better. In para G, we quoted the Supreme Court decision. The recent decision it says that entry into and departure from the service Air Force in terms of the provision is not a matter which lies at the suit will of a member of the Air Force.
When was this written filed? 26 or 25?
25. July 20.
Sure, position remains the same. There's only one radiologist, 2 radiologists in Sukhoi. But that's the reason only given that there's only 2 radiologists.
In subpara A and B at page 2, this affidavit is filed in November, only November. November 25. Subpara B, A, the Assam Rifle has a 150-bedded Assam Rifles Composite Hospital at Sukhoi, 2 more 50-bedded hospital, Assam Rifle Multi-Speciality Hospital at High Court Shillong, and another at Assam Rifles so and so at Mantripukri, Imphal, Manipur, are fully functional. That there is an acute requirement of one radiologist at the Assam Rifle Composite Hospital Sukhoi. Presently, there are only 2 radiologists who are general duty medical officer with postgraduate specialty. Out of these 2 radiologists, the petitioner submitted his application for voluntary retirement.
The only 2 radiologists in the entire Assam Rifles. How is that possible?
That's why you have to outsource many things.
Yes, Mr. Joseph, what to do?
My lord, actually, I'm in the same footing. Here, your lordship already decided. This is a covered case is there, but that was also the resignation case.
Which case is that?
This is WPC number 132 of 2025, your lordship. I just got your lordship. Huh? No. My learned senior also has insisted same thing. Resignation section 27 he has come up.
This was because of Park instruction from MHM, para 11.
Thirty-seven 3B.
Para 9 it is version 1.
So, this has gone to the Ministry of Home Affairs.
Yes,
not his case.
No, his case is not gone. His case is not gone.
But 27 actually is coming to play, Your Lordship.
No. See, this is a different footing altogether.
But my case is, Your Lordship, I'm not actually career progression or anything, only for my son.
Fine, we understand your case. But the thing is the operation of. So, what to do? You get instructions whether any alter arrangement can be made. Then we'll follow the same judgment. Yes, take down the petitioner who has completed requisite years in service had applied for voluntary retirement under Rule 43 of the CCS Pension Rules 2021. The request, however, rejected on the grounds that the Assam Rifles have only 2 radiologists present at the multi-speciality hospitals, of which the petitioner is one of them.
Yes.
One of them in this. This court has examined the materials and record, and also the prayer of the petitioner. Petitioner and the reasons are. Sorry. Yes, which shows that the petitioner, though eligible for VRS due to the circumstances surrounding, that is the shortage of radiologists, has not been granted permission by the respondent. In this context, therefore, NHCSCI has obtained instructions as to whether, apart from the 2 radiologists as stated earlier in the affidavit, other radiologists are available, or whether alternate arrangements can be made in consideration of the petitioner's prayer. This after 3 weeks. Yes.
23.
Obliged. Because I don't want to reject your prayer right now.
I understand.
I'm saying so others would want to reject your prayer outright.
Yes, sir.
Let them.
No, please, Your Lordship. Lordship, I'm praying for some accommodation, as the conducting counsel is not here, Your Lordship.
Where is he? He's outside.
Mr. D is not here, Your Lordship.
My lord, the parties, I have instructions that the parties have arrived at a settlement.
What settlement they arrived at? The PG Sama will apply, sir. Yes.
Lordship, we have come to the settlement only with regards to the payment of compensation, my lord. There is a compensation on the where both the parties on the earlier occasion that we have agreed that the compensation should be kept with in the account of the deputy commissioner until that case is resolved. Then another during the pendency of the petition, they have make an agreement that we want to share the 50-50. So we have filed this petition is filed both of us, both the parties. So we have enclosed the agreement also. They have, so we have enclosed in that.
Where you file a miscase?
Yes, miscase. That miscase number 50, my lord.
No, it's just that you mentioned in the morning.
Yes.
Miscase number I. Oh yes, sorry.
The page number 11, Annex 3, it is there, my lord. We have enclosed those.
Yes. You are Etterson Sangma?
Yes, I'm Etterson. Then the
Etterson is my son-in-law, and Kenola is the daughter. It's
a Tinder.
The dispute is within the family itself.
What's the amount?
That amount actually we don't know, but then it is the fact that money is remaining with the deputy commissioner.
So earlier agreement.
Conveyed
the commissioner pending some dispute. So going to be evidence and so.
Yes, the parapor of that page it.
It shall become the committee.
Yes, in parapor in the earlier agreement.
Yes, this miscase record. Miscase number 50/2026 in WPC number 126. There's a joint petition.
Yes, this is joint petition signed by the parties. Both the parties have signed.
This application has been filed by the petitioner and the answering respondent. Number. One number.
Answering.
Your respondent number 3, 2.
The respondent number 1 and 2.
By respondent. No, you are petitioner, Thinda.
My lord.
Yes.
I am the petitioner.
And respondent number 2 and 3. 1 and 2.
Respondent number 1 and 2 are the respondents. 1 and 2 are the respondents in the writ petition. I mean, in the revision petition.
In the writ petition?
And yes. In the writ petition, I am respondent number 4. The Peterson is respondent number 4.
Who is it?
Kinola is.
Kinola.
Yes, Kinola.
Both of you signed.
Both of us have signed.
This miscase is jointly filed by the petitioner and the contesting respondents 4 and 5.
Lordship.
Is submitted by the counsel for the parties that during the pendency of the incident petition, said this petitioner and respondents have arrived at an amicable settlement, which has been reduced in writing to a deed of settlement, which has been annexed to the notarized, notarized, and has been annexed to this case.
Annex 3.
As Annex 3.
Page.
They pray that in view of the settlement arrived at in the parties, the petition may be closed. This court has noted submissions made by the counsel of parties, also peruse the deed of settlement and make appended to the miscase. In view of the agreement that's been arrived at, whereas wherein the compensation money to be received will be divided by the parties using a ratio of 50/50. Nothing remains for consideration in this interpretation, and the same is disposed of.
Lordship. Much less, Lordship.
26.
Yeah, and this case allowed and disposed of. And in the main case, in view of the order within this. Yes.
Please, Lordship. Lordship, in this matter, I'm appearing on.
End of the board.
Lordship, I'm appearing on behalf of SK Hassan, Lordship. He's not keeping well.
So you become a hired gun now for adjournment. We expert adjournment, that's why. So,
Lordship, I'm on limited instruction, Lordship. Can you let the matter come after?
That's what I'm saying, a hired gun. Come after 3 weeks.
A week time, Lordship.
Yes, any objection?
No objection, Lordship.
2 weeks, yes.
Much obliged, Lordship.
Second call 14.
My lord, matters pertain to the promotion matter, my lord. Petitioner aggrieved by the promotion has not been granted to him on the ground that the ACR which he have earned during the ERE duty, my lord, that has not been taken into account, my lord. And
Whether the judgment,
my lord has
whether covered case, whether
judgment is
judgment.
yes, my lord, at page 22, my lord, annexure 4 in the writ petition. I have a next, my lord.
Yes.
And relevant portion is at page number 25, paragraph 4, my lord.
Yes.
At this juncture, this court has also examined the judgment placed by the learned counsel for the petitioner, wherein at para 13 thereof, this court had come into finding that the duty spent on ERE and the ACR grading earned by the petitioner thereof be considered for promotion.
Yes,
as much as
he also within organization, Dr. Mojika.
Within organization, my lord.
Then
yes, he was in my lord.
Which years?
My lord, from 2022 to 2024, my lord.
Extra regiment.
Sorry, 2020 to 2024, my lord.
2020?
In the year 2020 to 2024, my lord.
Or 2022?
He was on ERE duty. He was in ERE
2022.
At
yes, 2020. Is it 2022 or 2020?
My lord, in the clear date in the representation.
But I'm praying they will file an affidavit, my lord.
12.
You file affidavit here. Is for hearing?
It's not for hearing, my lord.
Is that for hearing?
This is for order, my lord.
I asked to take instructions, my lord.
Yes, yes.
It's a very fresh matter.
As the matter, no, as the matter, Mr. V. Kumar submits that the instant case is covered by the judgments of this court, as it concerns extra-regimental employment, consideration of extra-regimental employment. Dr. Mozika's praise of the 1 week's time of the instructions.
For affidavit, 3 weeks, my lord.
3 weeks?
3 weeks, my lord.
Okay, 3 weeks.
My lord,
I thought that was in the hearing list. Yes.
I will superannuated, my lord, in the month of May of this year.
Okay, 2 weeks. Yes, instruction.
My lord, much of lordship.
Yes.
16, my lord, pertains to the cipher category contempt.
Yes, what's happened? Complied.
Complied, my lord. The order has been issued, my lord.
Order has been issued.
Prescribing a timeline, my lord.
Dr. Mozika for his communication dated 19 March 26, that's yesterday.
Yes, yesterday.
Showing the factum of compliance. Copy of the communications made over to the counsel for the petitioner just after 1 week. Yes.
Yes, my lord, much of lordship.
3 of supplement.
1 second.
Next, please, my lord.
5 minutes, just give him 5 minutes.
Very well, my lords.
No, I'm not hearing. 5 minutes, just a moment.
Am I audible to my notes?
Yes.
14. Number 3, not 14.
This is item 3, my lords.
Item 3.
Please. My lords, I will be confining myself only to respond to what has been argued by the respondents since I have already addressed.
Before my friend replies, I'll just make a small submission, very brief. I'll draw lots of attention to page 327 of the writ petition.
Yes.
Well, this is 16th February 2009. More or less, their cause of action flows from here, and they are saying that this is mandatory. Our case is, my lord, this is not mandatory, it's only a directive, my lord. Now, my lord, the law on this, my lord, what is supposed to be mandatory and what is supposed to be, I'll place a decision, my lord, on that. Now, this, I'll just read few lines from this OM itself, my lord, which will indicate whether it is directory or mandatory, my lord. The para 2, if I just read a few lines, my lord. As cases continue to occur where confirmation, regular promotion, appointment to sensitive post, etc. could not be considered in time because of non-availability of ACRs for the relevant period, the matter of timely completion of ACRs was further reviewed in this department, and it has been found necessary to prescribe a timeline after which the so-and-so self-forfeit his right to record the ACR. It has been decided, my lord. Kindly.
Where?
Para 2, my lord.
Yes.
The first sentence I read.
Occur. Where did it from?
I read first, and as cases continue to occur where confirmation, regular promotion, appointment of sensitive posts, etc. could not be considered in time because of non-availability of ACRs for the relevant period, the matter of timely completion of ACRs was further reviewed in this department. It has been found necessary to prescribe the time limit after which the reporter self-forfeit his right to record the ACR. It has been decided that while the time limits prescribed in the aforesaid OM dated 23/9/85 should be adhered to as far as possible.
Yeah.
Well, this in itself, my lord, should be adhered to as far as possible. Will indicate the whole nature of this kind of directions, my lord. Secondly, my lord, these are only office memorandum. These are not statute or not even subsidiary legislation, my lord. Not even delegated legislation. These are only executive instructions in the form of OM, my lord. So, my lord, how far an OM can be mandatory, my lord? At the most, it can be directory. These are in the form of guidelines, my lord. Now, to this effect, my lord, so that is one aspect of the matter, my lord. Secondly, my lord, even if it is taken as mandatory, it has to be mandatory for both the parties, my lord. If he followed the timeline to the T, my lord,
yes,
maybe a reverse burden is cast on the department, my lord, to follow it scrupulously, my lord, when he himself is not following, my lord,
yes,
for both the years, and casting obligations saying that these are mandatory. I'll default, okay, but you cannot default. Well, I'll just read few para 10 of this judgment.
Sir, can just tell the citation, sir, I'll take it out.
Yeah, 1957 SC 912. And you've given a copy.
Yeah, 57. That's right, sir. 1957 SC
912. 912. So, but this decision more or less revolves around what is mandatory and what is directory, and it's a constitution-based decision. Para 10, I'll read, my lord. Few lines. The question may be looked at from another point of view. Does the Constitution provide for the contingency as to what is to happen in the event of non-compliance with the requirement of Article 323C? It does not either in express terms or by implication provide that the result of such a non-compliance is to invalidate the proceedings ending with the final order of the government. This aspect of the relevant provision of Part 14 of the Constitution has a direct bearing on the question whether Article 320 is mandatory. The question whether a certain provision in a statute imposing a duty on a public body or authority was mandatory or only directory arose before their lordships of the Judicial Committee of Privy Council in the case of Montreal Street Railway so and so. In that case, the question mooted was whether the omission to revise the jury list as directed by the state had the effect of nullifying the verdict given by a jury. Their lordship held that the irregularities in the due revision of the jury list will not ipso facto avoid the verdict of a jury. The board made the following observation in the course of their argument. The question whether provisions in a statute are directory or mandatory imperative has very frequently arisen in this country, but it has been said that no general rule can be laid down and that in every case the object of the statute must be looked at. The cases on the subject will be found collected in Maxwell on statutes so and so and following pages. When the provision of a statute relates to the performance of public duty and the case in such that to hold null and void acts done in neglect of this duty would work serious general inconvenience or injustice to a person who has no control over those entrusted with the duty, and at the same time would not promote the main object of the legislature. It has been the practice to hold such provisions to be directory only, the neglect of them, though punishable, not affecting the validity of the acts. Lordship will recollect there is a provision that if officer
so the preponderance, I mean, like of the validity is upheld.
validity, the action will not become invalid. Action will not become invalid. Maybe
no matter is irregular. I mean, like it's not as per due procedure.
My lord, at the most, the officer in default, my lord, can be punished for that. That's a different thing, my lord.
No, what's happened here now? They've been asked to show cause also, right?
No, my lord.
No.
Those reporting officer reviewing, sir, nothing has been done.
Hasn't been done. Yes.
Para 11, I can skip few lines, my lord. In the middle, it starts. This result could not have been contemplated by the makers of the constitution. It's about 8 line, 10th line.
Yes.
This result could not have been contemplated by the makers of the constitution. Hence, the use of the word shall in a statute, though generally taken in a mandatory sense, does not necessarily mean that in every case it shall have that effect. That is to say that unless the word of the statutes are punctiliously followed, the proceedings on the outcome of the proceeding would be invalid. On the other hand, it is not always correct to say that where the word may has been used, the statute is only permissive or directory in a sense that non-compliance with those provisions will not render the proceeding invalid. In that connection, the following quotation from Crawford of statutory interpretation, article so and so, is pertinent. The question as to whether a statute is mandatory or directory depends upon the intent of the legislature and not upon the legislature on which the intent is clothed. The meaning and intention of the legislature must govern, and these are to be ascertained not only from the phraseology of the provision but also by considering its nature, its design, and the consequences which would follow from construing it one way or the other. So, my lord, even on the reading, and this is simply an office memorandum, this is not an act of parliament. This can at best be a directory only. It can never.
This is 57 judgment.
This can never be mandatory, my lord.
Any other recent judgment? You know, it's been interpreted in many ways, Dr. Mozita, regarding this mandatory and directory.
My lord, if required, my lord, I'll pay lordship to declare that these are only directory. These can never be mandatory, my lord. This office memorandum.
No, that's that. But the thing is that once a memorandum exists, also it's expected that the authorities, comply the guidelines. But if there's a hint of maybe not malafide, I would say, with regard to how they appraise the ACRs, if it doesn't go as per the guidelines, what does it imply? What does it implicate? How does it affect the petitioner? We're looking at the larger picture. If you're looking at to balance equities or looking at justice, that is what. So whether the non-compliance with the requirements of guidelines, though not mandatory, they just in nature of guideline, has adversely affected the petitioner to totally in such a manner that it has caused irreparable harm to his service career.
Now, my lord,
that is one aspect.
My lord, their emphasis, what I could gather, my lord, from those submissions, is on procedure, not except a few reference on merit of whether 5.9 could have been
because
given
that
or not.
has been reduced by the reviewing officer, has been reduced from to
7 to 5.9.
7 to 5.9.
So that is a very valid consideration. Whether
our case is, my lord,
those entries at that point of time, whether he was already stopped by operation of these guidelines, or whether only the reporting officers entries should be taken into consideration.
So, my lord, if it is only a matter of delay, lordship holds that all these guidelines timelines are mandatory, my lord. then the reporting officer entry also goes, my lord. And
No.
the reviewing officer's
I'm saying
reporting
that
also entry
even
also
we
goes.
overlook the procedural irregularities that has happened, right? But whether looking at the larger picture, I'm repeating again, whether it has adversely affected the petitioner, that's anything.
And our case is, my lord, the reviewing officer applied his mind, my lord. It is not a case of routine or mechanical kind of writing of ACR. Malified, as I submitted, my lord, is 4 levels up. The petitioner, my lord, what malified, and it is their submission that he has never directly observed his work, my lord. He is Army Lieutenant General, my lord. They come on deputation to BRO for a certain period of 1 year, 2 years, my lord.
May I, my lords?
I'll just conclude.
No, let him conclude.
I'm so sorry, sir. I'm so sorry.
So, my lord, what I'm trying to submit, my lord, the timeline, even if it is given a nature that these are mandatory, my lord, they can invoke that mandatoriness of this, my lord, only if they are following it, my lord. If the petitioner is following himself, my lord. At the best, if petitioner submitted his ACR in time, my lord, reporting officer did not do it.
Self-appraisal, you mean?
His self-appraisal. His self-appraisal is also itself not there, my lord. And for the subsequent year, he himself has delayed it. He can delay it, my lord. Others cannot. The other officers cannot delay it. He is stopped from taking this plea itself, my lord. He has to be clean also, my lord, to invoke cleanliness from us.
Yes.
So to sum up, my lord, subject to what, if any arrangement is required.
Yes, Mr.
May I, my lords? Because in fact, I would like to start from where the learned senior has ended. I can be in default, but I cannot claim the respondent cannot be in default. But to begin with, it is shocking, and my lords, I'm using this word responsibly, that DOPT, which is a party to the case, which is being represented, which is submitting this point, is itself saying that its own OMs are merely directory. What's the second thing which is shocking is that despite there being relevant material on the record of the counter affidavit, I'm not even talking about my writ petition, still these submissions are coming. But I would begin with the last page of the counter affidavit. But every time it is being argued that I have submitted my APAR of 23-24 beyond time. But may kindly have the last page of the counter affidavit. But it is one thing to argue, but it is one thing to show the correct document. And this is the problem which I have been facing before coming to the court also, minutes. May kindly have the page 189 of the counter affidavit. But this is a document which on which the respondent has relied. It is a part of my writ petition also, but even the respondent relies on it.
Yes.
Has your lordships got that? This is a OM dated 28 May 2024. Has your lordships got it?
Yes.
Extension of timelines for recording of APARs for the year 2023 to 24 in respect of Central Civil Services. Your lordships may kindly have point 2.
Yes.
Submission of self-appraisal to the reporting officer by the ratee officer. Existing was 30th April. In the case of 23-24, it has been extended to 30th June. It is the admitted case of the respondents that I have submitted it on 24th June 2024. But my problem is, I may lose the case, I may win the case. That is different. But my respondent as a model litigant is at least supposed to at least show the documents which are being relied upon them and argue them before the court. It is one thing, whatever the result may be.
Yes.
But 23-24
is extended till 30th June.
30th June, and I have submitted on 24th June.
On
24th of June. Okay. Admitted case of respondents.
Not in order.
Yes.
Well, may now kindly have page 179 of the counter affidavit.
Yes.
But this is the no report certificate format 2324 bar issued by the chief engineer, Project Sevak, on 17th February 2025. Now, I'll be using this document for two purposes. Admittedly, it is the case of respondents that since January 2025, I am in Shillong. First impugned order of 22nd May 2025, I have already demonstrated that I was in Shillong when the impugned order which I have challenged, I was in Shillong. 17th February 2025, second apart. Again after January 25. And now that's the second point which I want to touch upon is the language which is used. The IPR for the period 1st April 23 to 31st June 24 in respect of Rakesh Chopra has not been written due to delay in submission of APAR by the rating officer. The reporting and reviewing authorities could not initiate and forfeited their rights to enter any marks in the APAR of the rating officer consequent upon the superannuation from service. The period from so-and-so in respect of Rakesh Chopra may be treated as no report period after issue of NRC. No APAR IPR for the above period will be taken on records. Why I am reading this? Actually, I plan to show this document a little later, but I am showing this because that is what has been argued. Page 327 is where the respondents started from. So may kindly have page 327 for a minute now. Again, from where the respondents started it.
Yes.
I would attempt to read the complete paragraph and not stop at any particular word or line so that the complete connotation of the document can be understood. As the subject is timely preparation and proper maintenance of the ACRs. That is the subject of this OM. The emphasis is on that it has to be completed timely. Now, what is the reason for timely completion? As cases continue to occur where confirmation, regular promotion, appointment to sensitive posts, etc. could not be considered in time because of non-availability of ACRs for the relevant period, the matter of timely completion of ACRs was further reviewed in the department. It has been found necessary to prescribe a time limit. After which the reporting reviewing officer shall forfeit. If this was merely directory, why would the word shall and forfeit appear together? His right to record the ACR. It has been decided that while the time limits prescribed in the aforesaid OM of 23rd September 85, this is 85, we are talking about 2009 OM, should be adhered to as far as possible because 85 was not mandatory. That is the reason of this OM. In case the ACR is not initiated by the reporting officer for any reason beyond 30th June of the year in which the financial year ended, he shall forfeit his right to enter any remarks in the ACR of the officer to be reported upon, and he shall submit all ACRs held by him for reporting to the reviewing officer on the next working day. Similarly, the reviewing officer shall also forfeit, once it is mandatory, his right to enter any remarks in the ACR beyond 31st August of the year in which the financial year ended. This is first part of this OM. I will pause here. Let there be any judgment, precedent, any rule, any notification, any clarification issued by the DOPT, which is a respondent in the case, which says that this is only directory and it is not mandatory. Now, the core emphasis of spoiling my APAR, the only thing which they could have demonstrated and which they have demonstrated is my non-submission of self-appraisal is a big blunder. That is the epitome of proving that how petitioner is irresponsible, is not doing his job well, and he's not entitled to promotion. His ACR should be spoiled. Once the second part deals with that. The section entrusted with maintaining the ACRs shall write forwarding the ACRs for self-appraisal with copy to the reporting reviewing officers. Also annex the schedule of dates as enclosed with. May kindly mark the next line. It shall also bring to the notice of the secretary concerned in the case of ministry department and the head of the organization in the case of attached and subordinate officers the names of those Group A and B reporting officers and Group A reviewing officers in the month of October after receiving the completed CRs who have failed. The secretary has to report to the ministry the names of those officers who have failed to initiate review the ACRs even by 30th June or 31st August as the case may be. I'll pause here for a minute. It does not even for a minute say 30th April. Why? Why it does not say. It only talks about reporting and reviewing. Why? The next line will answer that. The secretary in the department, head of the organization in the case of attached subordinate officers may direct to call for the explanation of the concerned officers for not having performed the public duty. The filling up of a PAR by reporting and reviewing officer, DOPT says it is a public duty of writing the ACRs within the due date, and in the absence of proper justification, direct that a written warning for delay in completing the ACR be placed in the ACR folder of the defaulting officer. This is the only OM in respect of the completion of the APAR with a timeline. I respectfully submit the respondent has failed to produce any document, OM, rule, regulation, law by which they can say that this rule says failure to do the self-appraisal is a default. It is a default of a nature which can entitle the employer to spoil the APAR, to give adverse remarks against him. What is being argued is misinterpretation of a document to punish me. If that is not malified, what it is. In fact, my lords, now I will come directly to the issue of mandatory and directory. But before I do that, my lords, let me just complete reading the next page of this document. My lords would remember I read last 3 lines of point 3, my lords. I would not repeat it. Page 328, I had already read the last 3 lines and your lordships had understood, my lords, in that case, if any officer fails, then what is the consequence? But what I am reading is point 4 now. That time, my lords, it was argued since there is no self-appraisal, reporting officer also goes, reviewing officer also goes, though ACR will be 0. But if your lordships would recollect that, the argument of respondents is for 2022 and 23, since there is no self-appraisal, as per the own case of mine, that if this is mandatory, then the reporting officer should also go, reviewing officer should also go. So my ACR is 0. Once the statute cannot leave anything in vacuum, the answer is in point 4. May I just read that? All the ministries, departments are requested to kindly bring to the notice of all concerned the above instructions for future preparation and maintenance of ACRs. These instructions shall be applicable for the ACRs for the period 2008 to 9 onwards. So that's after 2009. In the case any CR for the past period is pending completion, the concerned head of the organization in the case of attached subordinate offices and the joint secretary concerned in the ministries departments may take appropriate measures to ensure that the CR dossier is complete within the next 6 months, either with the relevant CR or the required no report certificate for valid reasons. Now, for valid reasons is also not something which has been left to any figment of imagination. But as far as this valid reason is concerned, your lordships would find that valid reason at page 308 of my writ petition. What could be those valid reasons which a NRC has to be issued with? Well, DOPT is clear in every aspect. It is only a matter of not being addressed to the Honorable Court. Page 308, point 5.5. May I, my lords?
5.5, yes.
Wherever there is any gap in the APAR during a particular reporting period, it is the responsibility of the officer in charge for maintaining the APAR to place a no report certificate indicating a reasons. Now, what are the reasons? The officer has not worked for minimum 3 years under a reporting officer. He was on leave training during the period. He was on unauthorized absence, if it is a fact. What's the last line, your lordships may kindly note? The APAR could not be completed by lapse of the time limit for making remarks by the retired reporting and reviewing officer. None of the document OMs anywhere it says self-appraisal is a crime, self-appraisal is a misconduct, self-appraisal is an act which would entitle the employer to hold me to account, because public duties casted upon the reporting and reviewing officer, not upon me. Why? because 2009 OM says the promotions get affected, the service gets affected, therefore it is expedient. After 85 2009 we are now issuing this notification OM so that every officer is fulfilling his public duty in a time bound manner. Now let me now address and assist your lordships in deciding whether that 30 days time period is mandatory or directory. I will again start by saying it is a document which has been relied upon by the respondent himself. Your lordships may kindly have the counter affidavit, page 59.
Page
59, my lords. Counter affidavit, page 59. Starts from 58, my lords.
Yes.
Has your lordship got that, my lords?
Yes.
14th May 2009. The subject is maintenance and preparation of APAR, communication of all entries, and lordships may kindly mark, for fairness and transparency in public administration. Principles of natural justice is the backbone, and to address that issue and to clarify any sort of arbitrariness, this OM is issued. What I would request and I would trouble your lordships to read 3 points with me, my Point number 4, Roman 4 on page 58 itself.
Yes.
The concerned officer shall be given the opportunity to make any representation against the entries and the final grading given in the report within a period of 15 days from the date of receipt of the entries in the APAR. The representation shall be restricted to the specific factual observations contained in the report leading to assessment of the officer in terms of attributes, work output, etc. So much my representation can only be limited to what has been stated in my APAR. While communicating the entries, it shall be made clear that in case no representation is received within 15 days, it shall be deemed that he or she has no representation to make. So if I fail to make my representation within 15 days of being communicated, my right to representation goes. Would the respondents concede today in writing that if any officer gives his representation after 15 days, will that representation will still be considered merits? And merits by respondents, I mean DOPT, not BRO merits. So merits may kindly read the next line. If the concerned APAR section does not receive any information from the concerned officer on or before 15 days from the date of disclosure, the APAR will be treated as final. But can this word be treated as directory? Now, what is more interesting is Roman 6 and Roman 7. Roman 6 I have already read, page 59. The competent authority for considering adverse remarks under the existing instructions may consider the representation if necessary in consultation with the reporting and reviewing officer and shall, I'll come to this, shall decide the matter objectively based on the material placed before him within a period of 30 days from the date of receipt of the representation. The argument of respondents is that the word shall is for deciding it objectively, not for 30 days period. But I could not find any rule of interpretation which would limit the word shall only to objectively decide. If the word objectively is mentioned, I would not, in my respectful submission, say that legislature should have used the word shall to emphasize that yes, it has to be decided objectively, but 30 days is directory. May kindly read point 3 now with me. All ministries, departments, point 3 minutes.
Okay.
All ministries and departments are requested to bring to the notice of all the offices under them for strict implementation of the above instructions. Your lordships, while reading that judgment of 1957 has asked if there is any recent judgment, I am carrying those judgments and I'll be supplying that to your lordships on the matter of interpretation and directly on the point. But the intent of the legislature since 1957 till 2026 has been the backbone of statute of interpretation. Shall and may is different. What is the object which the legislature intends to achieve? What's the very word strict implementation by no figment of imagination can be said that it was only for a directory nature. And words, interestingly, But the respondents have taken a few grounds regarding the jurisdiction which have not been taken in writing, which I'll be coming to, and I'll be also supporting my my argument with the judgment. But now I will request your lordships to have point 7, Roman 7 on this page notes. The competent authority, after due consideration, may reject the representation or may accept and modify the PAR accordingly. The decision of the competent authority and the final grading shall be communicated to the officer reported upon within 15 days of the receipt of the decision of the competent authority. So, my lords, there are 3 things which this OM says. The representation has to be made within 15 days, otherwise the APAR will be treated to be final. Second direction is on receipt of representation, it has to be decided within 30 days. And the third direction is once the decision is taken within 30 days, it has to be communicated to the ratee officer within 15 days. But 15, 30 and 15. But the intention is to ensure that no officer's promotion or any service benefits suffer because of this delay. Because it is the public duty of reporting and reviewing officer. Well, may I just, before coming to that judgment of mandatory and disciplinary, may I kindly request your lordships to come to the impugned order of 22nd May 2025 minutes. It starts at page 53 of my writ petition. And why I'm reading it and I'm troubling your lordships to read it again is because the respondent's crux of the argument is I'm only going on the technical aspects of this order. I'm not going on merits. But I would come to that as well. Page 53, your lordships has got the impugned order.
Yes.
But this 22nd May 25 is when I was in Shillong, admitted case of the respondents, but as per them, it is not an integral part of the cause of action. However, the fact is that this is an order which is challenged. It is my first prayer, my lords. Lords, may kindly have page 54.8.
Page?
And page 54.8. First line, lords. Page 54.8, lords.
Yeah.
And whereas the DGBR, via their letter dated 6th June 2024, have conveyed, but I don't want to read further. My representation is of 9th November 2023. Lords, let us assume that for a moment that everything is directory, not mandatory. For a moment, it is not my case, but let us for a moment test the argument of the respondents. Clause 7 says, upon the receipt of the order of the competent authority, it has to be communicated within 15 days. Mine is November 23. Representation is received by them on 13th November 23. That is their own case in the counter affidavit. 13th November 2023, DGBR gives his recommendation on 6th of June 2024. Impugned order comes on 22nd May 25. But I don't need to go to the merits. If this is not flagrant abuse of their authority to ensure I am victimized and my promotion is suffered, what else can be there, my lords? And what can the respondents today on oath say, my lords, that their own OMs with respect to the APARs are only for directory nature? It is, my lords, just to prove their point, my lords, it will be setting a very dangerous precedent. My lords, the respondents have argued that these are only guidelines, these are only OMs, these are to support the legislation. But has the respondent cited any legislation for the process of completing the APAR? No, because there is none. But these DOPT OMs are the only pieces of legislation which are the guiding light, which are the processes which have to be adopted by the department to ensure fair consideration to an employee who is in any ways considered and upheld by the Supreme Court to not have as much power as the employer. Once I'm an employee who's subject to the whims and fancies of the employer, to control those whims and fancies, these are the guidelines. But if the DOPT takes a stand before the Honorable Court that these guidelines which are enacted to support me to ensure that I am treated fairly are only directory and they can be executed in whatever way they want, but I would be left with nothing. No shred of dignity, my lords, while serving them. But the next thing which I want to point out, your lordships, now is the judgment, my lords, with respect to the interpretation. But I'm carrying two judgments, Bachchan Devi and Delhi Air Tech. Your Lordships, I'll just pass on those judgments. But Delhi Air Tech is 2011 Supreme Court, my lords. And what's Bachchan Devi, Supreme Court 2008. Delhi Air Tech, my lords. Has your Lordship's got that, my lords?
One second. Bachchan Devi.
What's I will read Delhi Air Tech first, my lords, and then Bachchan Devi. What's Delhi Air Tech? I'm reading from page 11, point 23.
What's the SEC equivalent?
The SEC equivalent, my lords, is 2011 9th volume SCC 354. But it's mentioned on the first page. SEC equivalent, my lords. 2011 9 SCC 354. Has your lordship's got that, my lords?
Yes.
Page 11, point 23. But I could read at least 18 paragraphs from this judgment, but I will only limit myself to 2 paragraphs. The distinction, page 11, para 23, the distinction between mandatory and directory provisions is a well accepted norm of interpretation. The general rule of interpretation would require the word to be given its own meaning, and the word shall would be read as must unless it was essential to read it as may to achieve the ends of legislative intent and understand the language of the provisions. But the legislative intent is strict implementation. Shall. It is difficult to lay down any universal rule, but wherever the word shall is used in a substantive statute, it normally would indicate mandatory intent of the legislature. Crawford on statutory construction has specifically stated that the language of the provision is not the sole criteria, but the courts should consider its nature, design, and the consequences flow from construing it one way or the other. Your Lordships may kindly mark the next paragraph, but that is where my case lies. Thus the word shall would normally be mandatory, while the word may would be directory. Consequences of non-compliance would also be relevant consideration. Consequence on me, mirrors. The word shall raises a presumption that the particular provision is imperative, but this prima facie interference may be rebutted by other considerations such as object and scope of the enactment and the consequences flowing from such construction. But the next line is I'll rest my case on this judgment. Where a statute, has your Lordship got it?
Yes.
Where a statute imposes a public duty and proceeds to lay down the manner and time frame within which the duty shall be performed, the injustice or inconvenience resulting from a rigid adherence to the statutory prescriptions may not be a relevant factor in holding such prescription to be directory. Even if the rigid adherence to it would lead to any inconvenience, does not mean that it has to be directory. Notice what they say is that this is only directory because this is only
this refers this in connection to which statute?
Land Acquisition Act.
Because this is what has been held by the Supreme Court.
But as a statute, anyway, yes. The same standard can be applied to guidelines or to
that is what the Supreme Court says with respect to public duty. But I wanted to come up with something which I can assist the Honorable Court. Public duty is what has been mentioned in the OMs which I am referring to. Supreme Court says public duty, even if it leads to some sort of problem with the empowered authority, does not mean they will say it is directory. Because we are in trouble because of it being interpreted.
Yes.
Lordships may kindly have Bachchan Devi minutes.
Yes.
Notice the SCC citation is 2008. On the top page, last line, what's third last? 2008. I'm sorry, not I'll wait.
12 SCC.
2008, 12th volume, SCC 372. 12th volume, SCC 372.
Yes.
But I'm reading from page number 4, para 11.
Yes.
The delicate question that remains to be examined is what is the position in law when both the expressions shall and may are used in the same provision. This is not my case, but still, this is the case where I am referring to a provision which has shall. The respondent's argument is that it has to be considered as may. Mere use of word may or shall is not conclusive. But Supreme Court says whatever may be the case, either of them is not conclusive. The question whether a particular provision of a statute is directory or mandatory cannot be resolved by laying down any general rule of universal application. And I must concede, I must concede here, the judgment which has been cited by the respondents is also on the same lines. It does not say anything which is different from this. Such controversy has to be decided by ascertaining the intention of the legislature and not by looking at the language in which the provision is clothed. And for finding out the legislative intent, the court must examine the scheme of the act, purpose and object underlying the provision, consequences likely to ensue or inconvenience likely to result if the provision is read one way or the other, and many more considerations relevant to the issue. But the object of this OM is for the timely completion, is for fairness and transparency. It is to ensure that the public duty of the reporting and reviewing officer, not the rating officer, not the rating officer, is completed within time, and the rating officer would have all the time as per the law to take legal recourse or to take whatever action he has to take in case of any adverse remarks. Right. But I will not repeat, but I will just request your lordships would recollect in both the judgments of Manu Dev Dahiya and Tarsen Kumar. I have specifically argued that the court has held whenever there is an adverse entry, it should be mentioned with the incident. Incident should be mentioned, and before any adverse entry is made, it should be put to the rating officer. Principles of natural justice process should be complied with, and once it is found after inquiry that yes, this apprehension or this allegation is correct, only then it should be noted in the apart process. But why I say so? Your lordships may kindly have page number 62 of the repetition.
Yes.
Page number 62, Manoj, of the writ petition. Point number 29 and 32.
Yes.
Do you agree with the assessment made by the initiating officer? If not, give reasons thereof.
Have you seen that? Yes.
So, Manoj, I don't want to repeat. I will answer what has been argued by the respondents. Partially agree, over assessed by IO. Manoj, it is, with due respect, akin to saying that while adjudicating any case, the honorable court passes a judgment, writ petition allowed because the petitioner is fair and just, and the respondents are at fault. But would that tantamount to a reason or to a conclusion? But the respondent's argument is that in compliance of the OMs, the reviewing officer has given reasons. Partially agree, over assessed by IO. That is the reason. Point 32, the IO has been liberal in his assessment. That is the reasoning as per the stand of the respondents, not my stand. If this is not conclusion and this is reason, I do not know how the honorable court would be in a position to decide whether any action of the departments are arbitrary or not. But in my respectful submission, to my limited knowledge, reasons are where the honorable authority, any authority, quasi judicial or judicial authority, reaches a conclusion after laying down the principles, considering the facts and not dealing with the law or not whatever reasons could be there, and pointing out the instances. This is a conclusion. Now, why I say this is a conclusion is, Your Lordships may kindly turn to page number 59.
No, we're not going back to the facts, are we?
I'm not. I'm
yes.
just. I'm only on the addressing what has been argued by the respondents.
He didn't argue this point. It
was argued that the reviewing officer has given reasons. I am only saying that if these are reasons, what else could be a conclusion? That is the argument which has been given by the MERS. In fact, the written arguments which has been submitted has specifically pointed out point number 20.
You already submitted written arguments?
The notes.
What's the written notes which was given to last year?
That was only for convenience. That's not a written argument.
These points have been relied upon. That these are the reasons.
See, so anyway, to cut things short, any other substantial point you have to argue?
Yes, but territorial jurisdiction.
Yes, that's only last point. The territorial, yes.
That's a major point.
That was the objection.
I have the judgment of Surishta Devi. I am referring to 2026 judgment, Surishta Devi. Has your Lordships got that, Surishta Devi? This is a 2026 judgment of the High Court of Jammu and Kashmir, Maharaj. And I would request your Lordships to have only 2 paragraphs.
Yes.
Page number 3, para number 13, Maharaj.
Yes.
But both the judgments, which have been relied upon by the respondents, I have seen them. They are only on the aspect of where the respondent is situated, and on the aspect of where the integral part of cause of action has arisen. That is the judgment which has been relied upon by the respondents. And those are again 2000 some judgments, very old judgments. But I would request your Lordships to kindly have para 13.
Yes.
Page 3 minutes. Has your Lordships got it? The first contention that is required to be considered by this court is with regard to territorial jurisdiction. According to the learned counsel appearing for the respondents, no part of cause of action has arisen within the territorial jurisdiction of this court. As such, the writ petition before this court is not maintainable. In support of the said contention, learned counsel for the petitioner has placed reliance upon the judgments of Patna High Court in Geeta Devi, thereafter Manager Allahabad, and Kusul Dots. This is one of the judgments which has been relied upon by the respondents. And the judgment of this court in Bhupinder Singh. What's para 14 now? In all the aforesaid judgments cited at bar by learned counsel for the respondents, it has been held that unless some part of cause of action, your Lordships may kindly mark this, some part of cause of action has arisen within the territorial jurisdiction of the High Court where the writ petition is filed, it cannot be stated that the said court has jurisdiction to entertain the petition. If no part of cause of action arises within the territorial jurisdiction of a particular High Court, the said court would not entertain the writ petition. Thus, let me kindly mark this. What is of paramount importance is the situs of cause of action. Now, what is situs of cause of action? If from the analysis of the facts stated in the writ petition and the material annexed thereto, it comes to the fore that even a fraction of the cause of action has arisen in favor of the petitioner, within the territorial jurisdiction of this court, the writ petition would be maintainable. The cause of action has been construed to mean the entire bundle of facts pleaded which are necessary to be proved before a petitioner can obtain a decree or order. It is not that every fact which has been pleaded would constitute cause of action, but it is only those facts which are necessary to be proved before a petitioner can become entitled to the relief prayed in the writ petition. Now, if I put a question to myself and to allay the concerns regarding territorial jurisdiction, my APAR was filed on 26 September 2023. My representation is 9th of November 2023. Let us for a moment assume that wide order dated 22nd May 2025, they would have rectified the APAR and the below benchmark grading would have been rectified. Let us say, albeit in contravention of the timeline, but that would have been rectified. But would have I got any cause of action? Would have any cause of action accrued to me to approach any court, be it Guwahati High Court, Delhi High Court, or not any High Court, if that order would have not been passed? Now, that order being passed by authority situated for anywhere from Jammu or Kashmir to Kerala, my lords, anywhere, the fact of the matter is part of cause of action. One part of that cause of action is the authority when they pass that order, and the other part is when I receive that order. But that is why the legislature and the Honorable Supreme Court is conscious of the fact of using the word part of cause of action. It does not say cause of action. But my grievance is not just the passing of the order, but it is a bundle of facts. I have demonstrated 2223 is a APAR for which impugned order is received when I am in Shillong. For 2324, that NRC certificate of 17th February 24, which again I am aggrieved because they say I have not submitted the self-appraisal. But is passed when I am in Shillong. And to top of it, let me just make a very much straightforward argument on this without any sugarcoating. But we have a respondent who did not object to the territorial jurisdiction on the same set of same nature of allegations in the earlier writ petition. Two, my lords, there is a reason the challenge of territorial jurisdiction and the jurisdiction of CAT is not mentioned in writing in counter affidavit and additional affidavit. I can show it from the record of the counter affidavit and from my writ petition. They themselves.
No, but the shown judgments that it need not go to CAT. Is that is.
But 1985 Supreme Court in the presence
that's not an issue anymore. That's not issue.
No, but still the department raises this argument. Only intention is to delay. But now territorial jurisdiction in the face of earlier decision, when they know that they have violated the rules, they have victimized the petitioner, the malified intention of the respondent is sought to be answered by one single line. He is a lieutenant colonel. He's 4 level up. How can he do anything with malified intention? Just 2 months back, the Supreme Court has held to account RBI governor for contempt and proceeding with malified intent against a IT-80 member. 2 months back. But if this is the threshold of deciding whether an officer of a superior rank cannot do anything with malified, but I don't think a officer with a lower rank having no power can act with malified against me. It is the person with power and authority who's going to act with malified. Why this is on 22nd May 25? Because they were waiting for the charge sheet to be issued to me on 22nd April 2025, which has been quashed by this Honorable Court. They wanted some adverse material to be against me on record, and that is till when they waited from 9th November 23 till May 2025. If this is not malified, then what it is? This is the 3rd time I am approaching the Honorable Court, and all the earlier 2 occasions the Honorable Court has held the action of the respondent is violative of the rules. They have not been able to prove anything. Honorable High Court says I am an officer of unimpeachable integrity, and the respondent says that is not a certificate. But if the observation of an Honorable High Court is not a certificate, then I don't know what it will be. But this Honorable Court on 24th November 2025 decides that the charge sheet is illegal, it cannot be upheld and it cannot sustain. But in December 25, in this very case, the respondents come to the court on affidavit and say that whatever action they have taken as per the charge sheet is correct, and the proceedings are pending. But this Honorable Court fixed the matter for argument on 15th of December 2025 because the DPC was to be held. But we are arguing in March. Why? Because the DPC was to be held on 10th December. The sole intent was to anyhow delay the proceedings in a way that the DPC is conducted, names are sent, and my promotion is hampered. But what else do I need to prove for malified intention? 2 court of inquiries, and both the inquiries were stayed. CVC issues an order to the department, don't victimize him. But Honorable High Court says, how can you even initiate this COI? This is absurd. The department makes a statement before the High Court that we will not proceed with this inquiry. But how else am I to protect myself? And what the last argument which they make is that if my argument of forfeiture of reviewing officer is to be accepted, then even the reporting officer's remarks should go, because that is beyond the timeline. But I have 2 answers to this. First, my lords, I have already showed what the rules say regarding the no report certificate, where it will mention that the reporting and reviewing officers forfeited their right, and that certificate will be placed on record. But my lords, here is a case where I have challenged only the reviewing officer's remarks. Respondents file a counter affidavit supporting the remarks of reporting officer and reviewing officer. Are the remarks of reporting officer even under challenge? That's the first question, my lords. As far as 22 and 23 is concerned, I will leave it to your lordships, my lords, whether there has to be a certificate of forfeiture mentioning that both the officers forfeited their right and they did not perform their public duty. As far as 23 and 24 is concerned, my lords, I submitted my self-appraisal within time, which was not been acted upon. And lastly, the respondents have themselves argued, even if it is mandatory, the department can take action against those erring officers. Must let the respondent prove that a duty which is casted upon the reporting and reviewing officers on not being fulfilled, whether there is any note annexed to their ACR record for not performing their public duty. I am being blamed for a duty which is not incumbent upon me. But the officers who have not performed their duty, they are being safeguarded because they followed the whims and fancies of the people who wanted to victimize me. And what's last thing? Just one last thing. Once I read that line, I'm in the habit of not listening to my superiors. I have a shaky loyalty to the organization. I'm a habitual offender. But am I a criminal? Is there any disciplinary proceeding, any charge sheet, any punishment order, any suspension order against me?
He is in the habit of, what is this?
Not listening to my superiors.
He's not listening.
What is that?
But that is what the adverse remarks against me are. But one
He is in the
incident when
habit
I am criticizing the
sizing superior officers and
But
his
is there
obeys
any
the orders.
incident?
He is a habitual offender.
Is there any incident? Is there any order? Is there any incident mentioned? Is there any notice issued to me? Is there any disciplinary proceeding which is pending? But they say they give me 5 points on integrity. They give me 5 points on integrity, my lords, and mention it as doubtful. 5 means good. As per their own point, page 59, 5 means good, but they mention doubtful. Why, my lords? But I am giving 99% marks to someone and says that he is a failure. I am only saying remove this failure. This is not in consonance with their own assessment. But the representation is decided after 18.5 months and they say that it is only directory. But if this kind of permission is given to respondents to decide the representation within 1.5 years, 2 years, but where will an employee who's at the whims and fancies of his employer go, Millers, in the face of so many malified acts? So my two prayers are 2023, 22 and 23 and 23 and 24 apars has to be rectified. 22 and 23 has to be as per the reviewing officer, and 23, 24 as per my self-appraisal. Second, my lords, the only way I can be, my lords, the justice can be served to me is, my lords, they have already held the DPC. I have given 2 judgments. Review DPC has to be held, my lords. And those no report certificates has to mention it is only because of the forfeiture of right by the reporting and reviewing officers, not because of my fault. I am not at fault. And what's a timeline? I'll leave it.
A brief suggestion, just few points on it.
Yes.
Now, my lord, may and shall and mandatory and directory, the judgments whichever have been placed with regard to law passed by Parliament, my lord. Now,
but even then, if we can draw the analogy with regard to see when this specifically been made that to adhere to timelines because of in public interest, correct?
Well,
so that nobody be deprived of the rightful consideration at the right time. So that also, even if it's not mandatory, but if you talk about what do you call it, even-handed justice, that is what. So
I follow, my lord.
You cannot
kindly
say that, okay, fine,
kindly see the delay, my lord. Kindly see the delay, my lord. 31st August versus 26 September. Only a delay of 26 days, my lord. It is not that the reviewing officer has put his remarks after 6 months or 8 months, my lord. So that will definitely come within it's not my submission, my lord. You can altogether ignore all this, my lord. But some leeway, my lord, some free play in the joint, because these are office members, these are executives, these are not law passed by Parliament, my lord. My lord, that will be my submission, my lord. That is my understanding of law, my lord. That is why I am placing with your lordship. That office memorandum cannot be interpreted in a way a statute is interpreted. That's one, my lord. Second submission, my lord, has been made that there is no challenge to the reporting officer's entries, my lord. Now, my lord, this is not an appeal and cross appeal, my lord. We are under 226. But these are submission valid only against a decree. There is an appeal and cross appeal, my lord. I don't understand how this plea can be raised.
Come again. He said that we have challenged the reporting of the reviewing officer's findings.
My lord, they are saying what they have challenged is only reviewing officer, my lord. First assessment period, my lord. And there is no challenge to the reporting officer because we have not filed a writ petition challenging that. Am I clear, my lord, on that?
No, not clear.
First year, my lord, there is no self-appraisal. Lots of you have seen that.
Yes.
Against the timeline, against the timeline of 30th June, my lord.
10th August.
Against 30th June, the reporting officer is on 10th August, my lord. And against 31st August, the reviewing officer is on 26th September.
Yes. Yes.
They are saying that in the writ petition, they have only challenged the reviewing officers being time barred, so that has to be expunged.
Whereas
our submission is that if that is so, even the reporting officer is time barred.
10/8/23.
10/8/23.
And the deadline was
30th June.
Yes.
So even that is time barred, my lord. So the submission has been made, my lord, that there is no challenge. We have not challenged. We have not filed a writ petition to challenge reporting officer, my lord. And because they have challenged the reviewing officer, so only reviewing officer should be set aside and reporting officer should be upheld with this.
How the argument hold good?
But that is my submission. But that argument can be, it is an appeal and cross appeal against a decree, my lord.
But that is not my argument. But may I clarify?
Yes.
That was precisely the argument, my lord. That there is no challenge to 10th July, 10/8. There is no challenge to that.
Very well, let me clarify. But my argument is that in the counter affidavit, the respondents are themselves supporting the assessment by both the reporting and reviewing officer. I am not saying they have not challenged it. I am saying they are themselves supporting both the views. In fact, today, if the APARs by the department are seen, 25% of the APARs will be beyond time. But only the reason they are not challenged is because that is why they are continuing. May I just show para 10 of the counter affidavit?
Let me just complete.
Yesterday, the argument is made that the defense secretary has decided my representation. He is competent authority. Two affidavits, nothing was mentioned on record. It is not decided by defense secretary, but they do not say it in writing, but they put it in arguments.
No, there's to and fro. It can go on for.
Let him finish. What's the other last point?
So, my lord, that was precisely the submission made, my lord. I'll go through the YouTube recording again. That was the clear submission. There is no challenge to the reporting officer's entry anywhere. So, this honorable court has to uphold that, or they cannot touch that, my lord. In my humble submission, that is very incorrect submission, my lord. That cannot be, my lord. Now, cause of action, my lord, the Jammu and Kashmir High Court judgment is no authority on this point, my lord. I placed Supreme Court decision. Some integral part of cause of action should arise with this honorable court. I submitted this was only fortuitous that he was posted at that point of time in Shillong, and that cannot give a substantial cause of action or integral part of cause of action. This honorable court has no jurisdiction, my lord. Now the most important aspect, my lord. Representation has been disposed of after 18 months, my lord.
Yes, that question is important, yes.
Now, your lordship, now what is the relief?
The effect of that?
What relief can be granted by this honorable court, my lord? Your lordship will either set it aside on the ground of delay. That can be one order that can be passed by your lordship, my lord, or direct us once again to dispose of. That will cause further delay, my lord. Will that entail, my lord, something positive in their favor?
Yes.
And with regard to 23-24, my lord, our case is that he was required to submit it before 31st January because the reporting officer was retiring and he has not submitted it by then, my lord.
With regard to?
The second assessment year.
23-24.
23-24.
He submitted?
On 24th June, my lord.
Yes.
Which
but time was extended.
Which he was required to submit by 31st January, my lord, because the reporting officer was retiring.
So on 24th June, But that was extended to 30th June by that OM.
No, my lord, that was in normal circumstance, my lord. When the reporting officer is retiring, he has to submit it before that, my lord. In this case, reporting officer retired on 31st January. And most importantly, my lord, the law, if your lordship lay down the law that whether these are mandatory or directory, this cannot be on the basis of any concession because office memorandum cannot be, in my humble submission, my lord, cannot be so mandatory, my lord. And the delay.
But what kind of
the delay of 20-24 days.
Are these just there for decorative purposes?
No, delay of.
I mean, then like only OMs just there. Are they just there for
No, but this can be a guideline that you cannot be.
It has to have some substance.
You cannot delay.
If you're issuing OMs and you're adhering to them, now there has to be what do you call some standard as to what degree you have to comply with them.
So, my lord, in my humble submission,
comply with them. That means you have to look at what does the OM say, right?
Yes,
with regard to especially when it becomes very specific with regard to timelines it prescribes. So you mean that just what's the point of issuing OM then if it's not to be complied with?
Lordship has seen if I may submit, my lord, these are only reiteration that because earlier not followed, you follow it more now.
Yes.
You follow it. Because earlier also timeline has been prescribed, but there are instances, there are complaints that it has not been followed. It is simply a reiteration of that you follow it.
Right.
And timeline is been given.
And so does it not
but
create
it is not
just because if there is a blatant inside of OM, what's the point of issuing
blatant, your lordship can attribute blatancy only to the second representation, disposal of representation, my lord. In 26 days delay, my lord, in my humble submission, is not a blatant delay. My lord, that will definitely come if your lordship holds these are only directory with to a reasonable extent, my lord. That cannot be 1 month, cannot be extended to 3 years, my lord.
To a certain extent.
Directly to that extent.
Because you see, the thing is, not in this case, other cases also, when the basis of office memorandums, like even the state insists when it falls to their advantage that it's the conduct of the business follow the OM. But now we can't have blowing hot and cold.
But the lordship
doesn't suit the case, doesn't work to advantage the respondents that it becomes
I follow that, my lord.
directory, and when
I follow that, my lord.
Lots of cases here, and when the advantage of the is mandatory. So okay, we look at every case, but in this case it involved a simple thing like APR,
and delay of 26 days, my lord.
Anyway.
But just one thing I want to say, I don't want to address everything. Just one thing, Merz would notice every time the focus is that somehow the matter should come back to the ball of the respondents. They will take a decision. No judicial findings should come.
No, I don't think government of India has so much grudge against you.
The other thing is,
these are hyper litigant. The 100% is pending. 100% pending for division bench.
On another.
You keep
why do you say the whistleblower? What did he expose?
Well, only they can say what whistleblower
yes,
they've done.
You have said that
I exposed corruption. I exposed corruption matters
within the organization.
And once when they use the word, I'm in the habit of criticizing my superiors. Let me just say it on record. Pressure was on me to withdraw it.
Yes.
Any part of, and the officers at that level, my lord, they come for 6 months, 3 months on the verge of retirement, my lord.
Taking loyalty, 2021, I achieved 103% efficiency. 30 years project is stalled. I am social gracious. That is the remarks given to me till 21. 34 years of service, my lords.
That by some blue-eyed officer, my lord. That's what is happening.
How can it be that every time the department can be correct, but it is only the employee who is at fault?
Well, I think we should leave it to lordship now.
I'm sorry.
But I need because to correlate with the pages, I need written notes and submissions. But the thing is that all my judgment getting held up because I'm serious shortage of private secretary.
But my notes will suffice as far as my submission will.
I don't think so. You have to correlate them with the judgments also.
I'll do that.
You file a fresh one within 1 week.
1 week.
Yes, a hearing. Written notes on submissions to be filed with. After 1 week, there's list on so and so.
Well, 1 week.
Very well, months, 1 week.
There's some holidays than that time.
After holidays.
No, no,
Yeah.
Those 8-9 days.
Weeks then. But things are, we are also very short of, it's become very difficult for me personally, the shortage of health categories.
Yes, ma'am.
And all the judgments getting held up. Some have already been translated, not even half, and they just. And the problem is that once it is not done immediately.
Yes.
You know it's that you have to recollect, and that's why usually it comes.
Must be filed within a week.
Yes. Yes. Once again.
Was deeply obliged for the patient hearing. Manoj. I'm so obliged.
Yes. Need you to teach us well. ये तो वही शेयर करो